最多你當係類似個 structure 點 run 你當嗰個。佢一個 revision 嘅係啦，但係嗰份係唔夠嘅。咁我 base on佢，就算我再加啲，其實我都係 structure。就你即係有啲人當係 revision 係呢個夠型版，即係呢個 lifetime 嘅，唔係嘅 ，OK， 唔係。雖然我都好想你哋理，但係唔係聽咗個堂有啲人講，聽咗個堂收啦。我覺得未必夠咯，佢俾得唔，即係佢啲料俾得咁薄。咁
在座咁多位係幾時交咗功課咧？尋晚嘅舉手。哇，好齊心喎！其他嗰啲咧更早。邊啲係今日？今日同尋日係咪佔咗大部分啊？應該。今日同尋日嘅交咗功課嘅舉手。絕大部分啦，應該係啦，咁都正常嘅。即係起碼你夠時候嚟上堂係已經係好好噶啦。Okay. Now, sorry, Mary, we were saying when did everybody hand in their homework so they can attend class tonight? So appreciate that. So keep me company. Now, tonight, our last topic, lecture topic 12. Now, you would think trial and post-trial matters. How can that fit into one lecture topic? Remember, this is like a condensed prelim course to introduce you to this kind of topics, right? Who's seen a white book? Okay, when we have time, I'll show you the white book. I am supposed to start properly, so let's start properly with our materials first. Okay, so tonight we're going to talk about the trial procedure very briefly, and then post-trial matters such as dealing with cost and enforcement of judgments, also briefly. Okay, I spoke too soon. Okay, I'm just going to use, this is my last lecture here. Okay, so most civil actions in Hong Kong have, or are heard before one single judge. Remember from your Hong Kong legal system that it's very rare for civil trials to have a jury, right? So most civil actions are heard at the CFI or the district court before a single judge. And therefore, that judge will make decisions or findings of both fact and law. It should be very cliche, or you should know this very well. Burden of proof is on the plaintiff to establish his case, meaning to prove all the elements. Standard of proof is on the balance of probability, so we call that the civil standard of proof. So how do we run with the trial? Now, we have the plaintiff giving his opening address, or sometimes we call it opening submissions. Okay, opening address by the plaintiff. So he'll briefly talk about what the case is, what the trial is here to decide, probably list out the narrowed down, now probably from the beginning, the final factual disputes and the legal disputes. After an opening address, depending how complex the case is, sometimes the opening address may only be 15 minutes, 30 minutes. Sometimes the judge would have read all the submissions and therefore only a few questions to ask the parties. Then we say is the plaintiff's evidence. Okay, plaintiff's evidence meaning what the oral evidence are from or includes from the plaintiff side. Remember I told you something about evidence in chief? Right? For each of the plaintiff's witnesses, okay, there would be 3 things done. Okay, so each of them. So each of them goes through this stage. Examination in chief, cross-examination. Okay, examination by chief is done by the plaintiff side. Okay, here we're on the plaintiff's case. It's done by Angela, right? Angela is my first witness on the plaintiff's side. I'm the plaintiff's counsel. Angela is plaintiff's witness number 1, or first witness. So first, she will be subject, or I will lead her in examination in chief. Remember I told you that with witness statements nowadays, so Angela wouldn't stand in or sit in the witness box and start from once upon a time. So all those information, what she wants to say or what she intended to give as evidence would have been mostly, predominantly, or almost 100% contained in the witness statement. So all I'm going to say is, I think I've done it in front of you, right? How an examination in chief was to him, right? Okay, so here we go again. Witness, please, you would have taken your oath or affirm that who you are, your identity, and affirm that, or take oath that you will say the truth and nothing but the truth, etc. Well, after that, when I come with to you and I say, Miss Angela, please open your witness, open the bundle in front of you, and turn to page 34. Okay, can you look at page 34, 35, and through to 38? Can you say what it is? And you say, this is my witness statement. Can you turn to page 38, the last page? Say, there's a signature at the bottom. Can you see it? Yes. Witness, you have to say yes or no. You can't just, okay? Or not. And whose signature is it? Mine, right? Your signature, okay. Can you please turn another page? And that's another signature there. Whose signature is this? Yours. Yeah. So do you confirm that the contents of your witness statement are true and accurate? Do you now adopt your witness statement as your evidence in chief? That's how it's done, okay? Then examination in chief is over, okay? After that, it would be the other side's counsel. Now I'm the defense counsel. I will be cross-examining you. The purpose, right, you are the plaintiff side's witness. The purpose for the defense counsel to cross-examine you is to tear apart the plaintiff's case. Right? So I will ask you all these things about, you said you did this, but you didn't, like just right, challenging the witness evidence for the plaintiff. So that's the cross-examination by the defense. Now, if there are things, okay, the third thing would be re-examination. So this is the plaintiff's counsel here again. We call that re-examination. The purpose is to try to repair as much as possible the damage the defense counsel did to tear apart the plaintiff's case. Okay, so I would say, oh yes, you said you couldn't, you didn't, what is it? You didn't send the defendant the letter, and can you clarify that? I gave her a chance to clarify matters that arises only from the cross-examination, right? Only from the cross-examination. Issues that I will let her clarify, but only what is raised during during cross-examination. And then Miss Angela would have done giving her evidence. So thank you, Miss Angela. You've finished giving your evidence. You may now leave. Please don't. But anyway. Okay, so that's how it is for each witness. For each plaintiff's witness, that's 1, 2, and 3. And then the next witness. Okay, maybe Simon, maybe James, maybe Mary, whoever. Okay? So, one by one, all on the plaintiff's side first. Then there will be what we call a close of the plaintiff's case. It's sort of a notional close. And then it's the defense opening address. Okay? And then the defense witness. Okay? So defense evidence would include all the witnesses in support of defense case. So again, that would be examination in chief by the defendant's counsel, cross-examination by the other side, so that's the plaintiff, and then that would be re-examination by the defendant, again to repair any damage. Okay, notice that why would we say, okay, this is quite open for them what to challenge. Re-examination can only clarify matters, be allowed to clarify matters arising from the cross. Why is that? You're not allowed to run wild because anything that is open should have been in your witness statement, right? Your main case should have been in your witness statement. And so here, you only limited to address things raised in cross-examination. Okay, otherwise it's like adding things to your examination in chief. So that's not allowed. After that, that's the defense closing address. You can either call it defense closing address or defendant's closing address. That's fine. Okay, so that's the defense closing address, and then the plaintiff's closing address. So that's in reverse order. So if you find it hard to remember the plaintiff, as the one bringing the claim, has the first say in the opening address and the last say. Right? They have the first word and the last word. That's an easier way to remember it. Okay, after that, the judgment. The judgment in civil case, unless it's a really, really simple case, a lot of times they are delivered another day. Right? In fact, in a real case, that if the trial lasts for a few days and the evidence, there's a lot of evidence, there's a lot of legal issues as well, chances are both sides' counsel will come back another day to make the closing address. Okay, after written submissions. And then yet after a certain period of time, the judge will deliver or hand down the judgment. Okay, but that's sort of the order. Okay, but the judgment normally isn't handed down the same day. Okay, it's very rare. Okay, so any questions there? Cost. Two overriding principles. First of all, no recovery of costs without a court order. So if both sides' counsel for some reason, plus the judge, forgot to deal with cost, everybody pays their own. Everybody pays their own costs. Okay, it's very rare, but that's the effect. If nobody talks about cost, at the end of the trial, everybody pays their own costs, because there's no recovery of costs without a court order. Secondly, the court always has discretion in relation to cost. Of course, there are certain guidelines, just like in our last or second last. Did we do Order 22 last time? Yes, I think so. In our lecture on Order 22, remember, there are quite strict guidelines unless there are exceptional circumstances. If there had been an Order 22 sanction offer and sanction payments, the court will normally adhere to those guidelines to give those cost implications. Remember those enhanced interest rate, indemnity basis, sort of cost order? Well, those are guidelines for the court. The court can always find that there are exceptional circumstances if it be true, right? But there are still guidelines. So in Order 62, rules of High Court or rules of District Court are all about cost. The whole order is about cost. Okay, it talks about normal cost orders and also about wasted costs and different kinds of cost basis. The court will take into account the underlying objectives as set out in Order 1, capital A, Rule 1. The purpose or the objectives is to increase cost effectiveness of procedures, ensuring the expeditious conduct of cases, so be quick, be cost efficient, and the third one is facilitating settlements. So three main objectives there. Other factors would be considered by the court. That's under Rule 5, 1A to G. It will take into account of any payment of money into court, any written offer expressed to be without prejudice, save as to cost. Litigation conduct of the parties, and whether a party has succeeded on part of the case. Okay, when we talk about conduct of the parties, we're not talking about your everyday life. We're talking about your litigation conduct. Have you been oppressive? Have you been making unreasonable number of applications that are irrelevant or useless, etc.? Right? Litigation conduct. Have you been refusing to narrow down your issues when you should have? Okay. Those are what we mean by litigation conduct. Whether a party has succeeded on part of the case. Remember we talked about how if there are 5 different limbs of claim and each party won some of them, so you may apportion the cost. Okay, who won more? Okay, which side has won more of those limbs or claims, right, of different claims. Okay, so yes, it's a pretty typical basis for argument on costs. Some of this we have sort of went through. So under normal circumstances, cost should follow the event. So whether the principle is whether it's an interlocutory application or whether it is the main action, the whole trial, meaning the whole action as a whole. So normally the losing party should pay the winning party's costs. Of course, there can be many reasons to deviate from that rule. Costs should follow the event. For example, we saw the rationale behind the sanction offer or payment. Counterbank offers by letter. Okay. Counterbank offers, as we saw last time also has a similar kind of wording, such as sanction payment and sanction offer, right? If you rejected this offer and you failed to do better, get a more advantageous judgment, then there may be cost implications to warn the other side. Okay, also conduct of the parties. Cost of or incidental to any proceedings. The court shall order the cost to follow the event except where it appears to the court that some other order would be more appropriate. So notice the word shall. What does the word shall, what is it equivalent to? Must. Okay, the word shall, it means must in any statutory provisions. Okay, the court shall order the cost to follow the event except when it appears to the court that some other order would be more appropriate. So where there are circumstances to justify the departure from that rule. Interlocutory proceedings, as we talked about it last time, the court may order the cost to follow the event, okay, which means wait till the end and see who won in the end, right? So may order the cost to follow the event or may make any other order it considers appropriate. Remember the example when Order 14 application is dismissed. What did it mean again? What does it mean again? It means it was, should the plaintiff had made the application? No, it's seen by the court to be totally inappropriate. Either some elementary criteria or precondition hasn't been fulfilled, such as the affirmation is not right, or the time has not expired, okay, etc. The time is not due, or the AS has not indicated intention to defend, etc., etc. So if an application should not have been made at all, seen to be totally inappropriate, then the court may not wait till the end of the trial. So dismissed with cause. The application is dismissed with cause. And if it's so inappropriate, the court will normally give a court cost order then. Okay, there and then. So normally it would be the defendant's cost, right? Because the plaintiff was not right. Second point there, the court uses its discretion on cost for interlocutory applications to deter unreasonable applications. For example, another example may be remember security for costs for plaintiff by the defendant, an application by the defendant against plaintiff who ordinarily resides overseas. Do you still remember? Right? Security for costs. Application by defendant saying, yes, you live overseas. What if I won and you lose and I don't know whether you have money or asset to pay my costs. Remember that? Right? So what if the defendant made such an application, but actually the defendant does reside in Hong Kong, ordinarily reside in Hong Kong. Even stage 1 or the prelim condition is not satisfied. So that's quite inappropriate, right? It should have been dropped or never proceeded with, or never made. So that's another example where it might have been. The court thinks, yes, it's an unreasonable application. The defendant knew the plaintiff lives or ordinarily resides in Hong Kong, and yet they still make the application. So we should punish them with costs, so they should pay the cost for that application. They can also order summary assessment of costs in lieu of taxation. Normally, if it's at a very early stage, okay, two things can happen, right? For the cost of an interlocutory proceedings, perhaps the cost is not a lot. Both sides, maybe only the solicitor had attended. Okay, it's been relatively simple. So the court may, instead of sending the bill to taxation, just make a rough figure estimate of the costs and ask the other side, the losing side, to pay for it. Okay, so instead of saying, go and see to taxation, you may say, okay, this should have taken you roughly about however many hours, so just make it 10,000 costs or 5,000. Okay, give a rough figure. Yeah, I think we've gone through this last time. Usual cost orders in interlocutory proceedings. Cost in the cost we know, right? For here we're looking at interlocutory proceedings. Okay. So if we say cost in the cost, let's wait till the end. Let's say the plaintiff wins. So in the end, for that interlocutory proceedings, because the plaintiff wins or has won the main suit, the main trial, the plaintiff will also get the cost of that interlocutory proceeding. Plaintiff's cost in the cost, I think I explained to you last time, right? The only difference between cost in the cost and plaintiff's cost in the cost is that only the plaintiff will get the cost if the plaintiff wins. If the defendant is the winning party at the end, nothing happens, no cost order. Okay, the plaintiff, again, if the plaintiff wins, the plaintiff will also get the cost of this interlocutory proceedings. But if the defendant wins, nothing happens. They each pay for their own cost for this interlocutory proceedings. Okay. Number 3, plaintiff's cost in any event. Okay, if it's plaintiff's cost in any event, the plaintiff will get the cost. Okay, no matter who wins, who loses. The party in whose favor the cost order is awarded will receive the cost of the interlocutory application, whether they win or lose at the trial. The costs are taxed after trial. Okay, so many variations. Okay, plaintiff's costs payable forthwith. I'm just going to ignore, I'm just going to pick one side. Okay, plaintiff's cost payable forthwith. The party in whose favor, which means the plaintiff will be awarded to the cost. Forthwith. Forthwith means immediately. That's another wording. Forthwith means immediately. But if the cost or the bill of that cost is subject to taxation, it will be paid immediately after, or very short time after taxation. Okay, if it's already summarily assessed, like summarily assessed at 5,000 Hong Kong dollars, payable forthwith to the defendant, then you don't need taxation, right? Because this figure has been estimated to a fixed sum, 5,000. So the plaintiff pays the defendant immediately 5,000 as cost for that interlocutory application or hearing. Cost reserve is saying nothing except that it will be decided later. Okay, cost reserve. So for that interlocutory application, the master is not saying who's going to pay whose cost. Let the decision be decided by the judge in the end. Okay? No indication here who will get paid. Okay, that's cost reserved. No order as to cost. Okay, you each go home. Pay your own costs. I'm not going to give any cost order. Nobody's paying anybody else's cost. Okay, each party bear its own cost. Cost of an occasion by is just a description of how wide a scope that cost order covers. Such an order is commonly made where the court grants a party an indulgence, such as leave to amend a pleading or an adjournment. So Angela wants to amend the defense. Okay? Out of the blue, well, you want to amend the defense, you are causing some change, and probably the plaintiff has to amend the reply. Right? So cost of an occasion by the amendment of the defense would be borne by Angela, because she's the one asking for an indulgence to amend the pleading. So more likely than not, the cost occasioned by the amendment of the defense and the amendment of the reply by the plaintiff would be borne by her. Okay, so cost of an occasioned by, arising out of it. Okay. Any questions so far on cost? Enforcement of monetary judgments. Okay, enforcement of monetary judgment. First of all, I will ask you to turn to page, turn a few pages down to Order 48. I think it's just the next page. And then 2 more down. Do you have this page? Or this slide? No? Have I updated it for you? Do you still have this slide? Yes. Can you cross it out? This whole slide. Okay, this is about Order 48, but it's not correct. Okay, Order 48 does not carry with it any imprisonment. Okay, only 49 capital B. Okay, that's so. In the same vein, can you turn to page 89 in your course manual? Again, page 89. In your course manual, at the second paragraph, the highlighted, please cross it out. Okay, the first sentence in the second paragraph is correct, the rest is not. Okay, including the points 1 to 3. Okay, but the first line or sentence is correct. Okay. So because I only got confirmation. I had a look at the rules in the provisions, and there is nothing that says that. So I got confirmation later from the staff or the person in charge. Okay. Now, well, what are we after in civil litigation? Money, right? We're not here just to fight so that to prove we are right, correct? We want something back. So after a judgment is handed down and after the cost orders are sorted out, you want to get the money. Otherwise, what's the point of going through all the trouble? Now, in reality, that's not as easy as you may think, right? Because sometimes, remember winding back to your pre-action considerations. Remember we told you, yes, you should check the finance background, asset check. Is the defendant worth suing? right? Remember that? Because otherwise, we said you may get an empty judgment. Okay, an empty judgment, which means yes, you won, but you can't recover anything. Okay, after judgment is pronounced, assuming, let's put it in a simple scenario, that the plaintiff wins. The plaintiff will be the judgment creditor. Okay, because he'll be entitled to be paid under the judgment. So judgment creditor, and the defendant is the judgment debtor. But is it always the case? Why? Plaintiff's making a claim, isn't he? Well, what if there's a counterclaim and it ended up that the plaintiff's claim failed and the counterclaim was substantiated, right? The defendant can also be judgment creditor in that case. But let's assume this is a simple case. So when you deal with enforcement of judgment, to be entirely correct, you should use the word judgment creditor and judgment debtor. Then you'll always be right. Okay, always be correct. Okay, now let's assume a more simplistic scenario, and the plaintiff won. The plaintiff can apply to have the court conduct an oral examination in which the defendant is questioned about his financial capacity under Order 48 or 49B, okay? 49 capital B, Rules of High Court. Okay. That is for examination purposes, okay? To find out the financial details or capacity. Now you can do that depending whether it's okay. Now both Order 48 and Order 49B provides for that kind of oral examination. So what's the difference? Okay, for Order 48 first, it provides an oral examination of the defendant to determine, well, we should call it judgment debtor, right? Just assume it's judgment debtor, to determine what debts are owing to the defendant and whether and what means the defendant has to satisfy the judgment. In other words, how much money and liabilities you've got, can you pay my judgment award to me? Covers individual as well as company directors. So it can be applied to both natural persons and company directors. Okay, so if a company is involved. Now this time, you will notice, now we have been doing inter partes, right? Till the end of the world. Now, here, when we do enforcement of monetary judgments, you will see a lot more ex parte applications. Why? If I tell you in advance, you're my victim tonight. Angela, I'm going to come after you. What would you do? Grab the money and run, right? You would try to evade. So that's why when we have money enforcement actions or enforcement procedures, a lot of them are ex parte applications. Okay, at least the initial bit. So plaintiff makes an ex parte application, no leave is required. So when you see, well, what do you mean no leave is required? Don't I have to apply everything with the court or registry or whatever? It means that it's automatic. Like when you have that application stamped in the court, issued from the registry, it's automatically issued, right? We'll look at some of the different types later. But here, when you apply for an oral examination under Order 48, it's an ex parte application, a date is set for you for the oral hearing. Because you do want the defendant to be there, the defendant is then notified and told to bring all relevant documents concerning his financial position to the oral hearing. Now don't get confused. A lot of people get confused because of all this wording, was ex parte, and then attending, and then notification. So aren't you saying I shouldn't notify him or her? What do you mean ex parte, and then why should I notify? Don't get confused. When you apply, right, you're applying for an Order 48 for Angela to come and tell me all about your financial details, right? The application is ex parte. I don't need her to be there when I apply for that order. After I apply for that order, Angela, I've got this order now. You have to come. That's when she gets notified, after the order is issued. Do you understand? Right? So it's sort of the next stage. Of course, I need to notify her because she is who I need to be here to be orally examined by me. Right? So don't confuse why ex parte and why notification. Right? I got the order by ex parte application. And then under the order, I'm like commanding her to be here. Okay? So the order for hearing must be served personally on the defendant, so the defendant would not have an excuse saying she doesn't know. The court may also order for the discovery of documents prior to, as well as after the oral examination, Lavage, SA and Continental Cement Corporation. The examination is conducted in an open court before a master. If there's any dispute as to whether a question should be answered, the dispute is referred to a judge, so a higher authority. Now, why can there be dispute as to whether a question should be answered? Well, whether it relates to the financial capacity, right? Or is the plaintiff just trying to humiliate or making trouble? It can be, because sometimes people say that Order 48 and Order 49B, the oral examination, they are arguing that some people do it to humiliate, right? Because you're asking somebody to sit and ask, you don't have this, do you have this, do you have this? It's like, interrogation in a way, milder way, but it's, asking a lot of details. So if there's a dispute as to whether a question should be asked, sometimes that happens, right? We said no imprisonment for Order 48. Okay, under Order 48, no imprisonment. Order 49B, so the other oral examination of also the defendant's financial position. And Order 49B examination addresses the execution and enforcement of money judgment. Perhaps a better word, or it would sound more professional, would be monetary judgment. Okay, so up to you. Monetary judgment. The plaintiff makes an, guess what? Again, ex parte application for the order. Again, no leave is required. Same thing, right? The date is set for the oral hearing again. Defendant or judgment debtor is notified and directed to bring all relevant documents concerning their financial position to the oral hearing. Again and again, order for the hearing must be served personally on the defendant, so the defendant can't say he or she doesn't know. The court can make an order prohibiting the defendant from leaving Hong Kong for the purpose of that oral examination. Examination, notice here, is conducted before a judge. The other one before a master. Okay, so 49B it's more serious. We'll see how. The defendant at the hearing has to make full disclosure of all assets, liabilities, income, expenditure, and of the disposal of any excess or income. He shall, subject to the directions of the court, answer all questions put to him. Okay, so already we saw that it's before a judge. It's slightly different. We'll see we'll compare 48 and 49B a little bit later. Still under Order 49 capital B, the court has the power to direct the defendant to make payments by installments. Again, Order 49B is the only one that can have imprisonment of the judgment debtor for up to 3 months if he fails to attend the hearing. The hearing is adjourned, as in pushed to a later date, and there are reasonable grounds to believe the judgment debtor will not attend the hearing. The judgment debtor fails to make full disclosure of his financial position. The defendant has disposed of some assets in order to avoid satisfying the judgment. Notice that the imprisonment does not wipe out the debt. So when you get out, you still have to pay. Comparing 48 and 49B, this is a very superficial comparison. In actual fact, there's been arguments that they overlap with each other and they should be merged into one, but it's still a debate. Okay, 48 applies to individuals and as well as companies. Okay, company directors. Under Order 48, there's no power of arrest or imprisonment. No power to make prohibition orders. Whereas under Order 49B, it applies only to individuals, natural persons. Power of the court to arrest and imprison a judgment debtor and also to make a prohibition order to prevent the judgment debtor from leaving Hong Kong. In actual fact, there are further differences. I don't think, some of them may not be in your course manual, but just additional knowledge is Order 48 can be used for oral examination against different types of judgments, not just monetary judgment. Whereas for Order 49B, capital B, it's only to enforce monetary judgment. Okay, that's another difference. If you want to put down, this is a very simplistic table, I should probably improve it. Another difference is that one is before A, 48 is before A, master, and 49B is before A, judge. And if you ever get confused which one has imprisonment, who do you think has the power to order imprisonment, a master or judge? So you can remember easily. Okay? The 49 capital B. And in a way, if you think about it, it makes sense. When you have power to imprison, well, you need high authority, because civil litigation is only very rare that you will order imprisonment, because it's not criminal, right? If it's imprisonment, you're taking away somebody's liberty. So most of the time that occurs only like for things like contempt of court, things like that, because contempt orders or imprisonment orders, they are like quasi-criminal almost. That's how people have been describing it. Quasi, so de facto, right? Quasi, half criminal. So, and 49B, although you think, oh, isn't that more limited if it's only for monetary judgment? But if you think about it, if you've got monetary, if you say, oh, somebody didn't do something, it's a bit vague. Somebody didn't pay a certain amount of money, it's more solid, like it's more concrete, right? More identifiable. Okay, somebody having the means but not paying, etc., etc. Okay, any questions here? Okay, I don't know if you guys can tell the others about this and the part in your, because some people might not have come tonight. So if you can, please remind me to do it maybe perhaps in the revision class, because it's only next week. So just in case I forget, please. Okay, oh, somebody is being, can you do that too also? And tell your classmates, that's page 89. Okay, the highlighted should be crossed off. This Adobe wouldn't let me strike through. It's very limited editing function. Okay, so there we go. Okay, some action here. Okay, writ of fieri facia, commonly known as fee-fa, F-I-F-A. Okay, writ of fee-fa. Now, this writ is not writ of summons, okay? Do not confuse just because it's got a writ. That's actually, for enforcement action, they're different kind of writs. They are sort of enforcement kind of writ. Okay, it just means a document to enforce. you can have writ of FIFA, you can have writ of possession, okay, different types. So what this writ of FIFA under Order 47 allows us to do is for the judgment creditor to go to the defendant's premises or judgment debtor's premises to seize valuable goods. A method of enforcement of judgments which allows the judgment creditor to seize goods, chattels, or other movable property which are of some value, right, in execution of the judgment debt. So basically, you seize the goods, and if the defendant still doesn't pay, you sell them. Okay, you sell them, you put them on sale. So Section 21, capital D, subsection 1 of the High Court Ordinance place some restrictions on what type of property can be seized. You cannot seize, you cannot take away, under the writ of FIFA, hire purchase items. Guess why? If you have something on hire purchase, does it belong to you? No. Well, if it doesn't belong to James, then a third party shouldn't be able to come and catch something. Let's say it's a car, it belongs to ABC Motor, okay? It's a hire purchase fleet. So it doesn't belong to James. So even though James owes me money, under the judgment, I can't go and seize that car because that car doesn't actually belong to James, right? As simple as that. Other items not belonging to the judgment debtor. Tools of trade or occupation up to $10,000. So let's say you're an electrician. So your tools of trade, your drills, your hammers, your normal knickknacks, which you need to do your business or work, okay, can be immune, right? Up to $10,000. Reasonable amount of bedding and clothing. That I think is self-explanatory. Why? A writ of FIFA must be sealed, and we remember what sealed is, right? That stamp. The bailiff goes to the premises. You have to pay for the bailiff, though. That incurs some cost. Okay, that's like a court officer. The bailiff goes to the premises of the judgment debtor without prior notice. Okay? Without prior notice to the judgment debtor, and has the power to seize goods to the value of the judgment and cost. The judgment debtor can apply for a stay of execution. Okay? The person owing money can apply for some time. Okay? Normally the bailiff will not physically take away the goods at the first round, but will create an inventory of goods to be given to security personnel guarding the premises. The defendant will be given 5 days to pay the judgment debt and as well as the cost of the execution. If the judgment sum is still not paid, the goods may then be sold at a reasonable price, usually at an auction, under the court's direction to realize the money owed, which is then given over to the judgment creditor. So basically, a court bailiff goes to the judgment debtor's place, sees some valuable goods, make an inventory first, and if still not paid the judgment sum, then have them sold. Quick question. Why can't I just go over to James' place and seize the goods myself? He owes me money. Why do I have to engage a court bailiff? Yeah, I'll be considered a thief, right? Without any, without doing that procedure and engaging a court bailiff, he can just ring the police and have me arrested for theft. Right? It's just like when you have landlord and tenancy dispute, even though you think, or even have property title dispute, you can't just go over and break open the property store, right? Because nothing's proven yet. If you do that, then you may face criminal charges, right? Not only about trespass, also you learn about trespass, right? To the land as well. No, you haven't done land law. Okay, you can have trespass to the land, or if you damage some other property at the premises, they may sue you and turn around and claim against you, right? So not recommended to do that on your own. Okay, some of this may be a bit, it's sort of a bit of fun actually. Okay, garnishing proceedings. Okay, if you have any questions from the above, stop me, but otherwise. Okay, garnishing proceedings. Now, the concept is quite unique. So let's read through this slide first. It's a process where if a third party, the garnishee, owes money to the debtor, the court orders the third party to pay the money to the plaintiff rather than the debtor, the judgment debtor. The garnishee really doesn't help, right? Not much microphone like that. Okay. Garnishee orders can be used only where the original judgment debt was more than 1,000. I think if less than 1,000, you wouldn't bother, right? Okay, just to have people to go to the court and do all this application takes time anyway. It's commonly used against bank accounts, but can be used in other circumstances too. Okay, without finishing the last point, what is garnishing proceedings? It's all about third party owing money, who to who. Okay, basically, to put it into context, Candace, Tommy Construction, right? Candace, okay, he's in a nice jacket. I'm going to say he's richer. Okay, Tommy is the judgment creditor. Sorry, I'm very prejudiced by crime. Okay, so Tommy is the judgment creditor and Candace the judgment debtor. And they hold, Candace hold an account with UCO Bank. Okay, that's a bank. So Candace owes Tommy money. Candace has money in the bank. The money in that bank, in UCO Bank, is like a debt the bank owes to Candace because those money in the bank account is Candace. Do you agree with me so far? Okay, so money there is money owed to Candace by the bank. So actually, guess who's the garnishee? Okay, that's the garnishee. Okay, because that's the one owing Candace, the judgment debtor, money. So what we are saying is, bank, bank, bank. Magic bank, please give, Tommy is saying, please give me the money that you owe Candace. Instead of giving it to Candace, give it to me. Give it to Tommy, basically. Right? So that's basically what it is. So Tommy will apply under Order 49, Rule 1, against, not Candace, against the bank. We don't need her. She's sort of half vague in the picture because we just want to get the money from the bank. Okay, so the order is actually against the bank in this case. Orders, and we're getting a court order to order the third party, the bank, to pay the money to the judgment creditor, Tommy, rather than Candace, the debtor. Okay, so once you put it into perspective, you know what I mean. It doesn't have to be a bank or finance company or whatever. It's just somebody who owes the judgment debtor money. Commonly used against bank accounts, but can be used in other circumstances too. Bank can exercise the right of set-off. Let's say Candace has 100,000 in that bank, 100,000 cash, Hong Kong cash. However, let's say Candace this month has spent a bit of money on her credit card, 20,000. Okay, so the bank can exercise the right of set-off. So 100,000 minus 20,000, 80,000. So the net amount that the bank owes Candace would be 80. And that's what Tommy can enforce. using garnishing proceedings. Okay, and that's what I mean by right of set off. I give you an example. This is all added last time. That's why I can't even remember that. Okay, so I think this is pretty similar to what I just did with Candace and Tommy. Okay, judgment sum of 100,000. Judgment debtor has 50,000 in the HSBC bank savings account. So HSBC owes the judgment debtor a sum of 50,000. But the judgment debtor, Candace, also owes 20,000 on her credit card. So creditor can apply a garnishee order against HSBC as the garnishee, so that HSBC would pay the balance in the account to the creditor. Okay, but after exercising the right of set off, deducting that 20,000 credit used on the credit card, so 50,000 minus 20,000 is 30,000, which would be the final sum paid to the judgment creditor. Okay, just exactly what we did with Tommy and Candace and Yuko. Okay. Okay. Guess what? Again, ex parte. Now, be careful, some of this do not require summons, and you can apply for it by affirmation. The court seals a garnishee order nisi. Remember, when you see the word nisi, it always means provisional. Seals a garnishee order nisi, which is served on the garnishee, in our case the bank, and the defendant. So we'll let the defendant know that yes, we're going to take over that balance from your bank account. So the defendant or the judgment debtor does know or does get to be notified, but he's not in the chain of our action. Okay, he's not really involved in the direct action. The direct action is between the judgment creditor and the bank, the garnishee. And what that order does is to direct the garnishee bank, I'm just going to keep it on saying bank as well, to attend the court on an appointed hearing to show why the orderizer should not be made absolute. If the garnishee fails to attend the court or fail to persuade the court why it shouldn't be made absolute, the garnishee order absolute will, well, the order nisi will become absolute and will direct the garnishee to pay the money to the judgment creditor. If the judgment creditor still fails to pay, the order can be enforced against the garnishee as if he were the judgment debtor. Okay, so I think that's that for the moment. Okay, so basically that's that. So why can there be instances when the garnishee, how can the garnishee persuade the court? Well, in our case, perhaps Candace not only owe the 20,000 in the credit card, perhaps there's a mortgage, there's something else, right? Perhaps there's more information to be taken into consideration. So the garnishee is actually, it's after right of set off, perhaps there's no balance. Otherwise, perhaps there's a mistake, but otherwise, normally it's pretty standard that the order will become absolute. Okay. I think we will take a break there because I think they want you to fill in an evaluation form of me. Okay, so I'll ask them to, and we'll take a break after that. So they don't have to wait. Ready? Any questions on this? I think this is pretty cute.